Good afternoon and welcome to How to Avoid a Lawsuit. I'm Angela De La Housaye Ashley, and I am founder and managing attorney at DLHA Law Group. I'll be moderating today, and I'll also be presenting along with two other of our attorneys who are also panelists. Thank you for giving us a full hour of your time and welcome. Let me tell you a little bit about our firm before we begin. I founded the firm over 21 years ago, and we are a full service business law firm. And we handle both business law issues and also employment matters, as well as a whole host of other issues and situations that may come up for employers and businesses. It's important to note that what you are seeing today and what you're hearing is not legal advice, because to give you sound legal advice, we would have to meet with each of you, understand your particular scenarios, the issues you're facing, and the facts that support whatever your circumstances are. But we are giving you an overview of how to avoid lawsuits. And if you have any questions after the webinar or during the webinar, please feel free to reach out to us. We'll have a Q&A box. It's at the bottom of your screen. Use that rather than the chat box for questions. And when we're done with our presentations, we'll address each question individually at the end. Also, though, if you want to reach out to us at our firm, you can reach us by calling the number that's shown on the screen or using the info@dlhalaw.com. That's also on the screen, and it should be on every screen as we go forward. So as I said, there will be three of us presenting today. I'll be presenting after Kellen Stevens, and then Lindsay Meyer will be presenting. Lindsay is our senior employment attorney at DLHA Law. She leads our team in providing legal advice and representation to businesses to ensure legal compliance regarding both federal and state employment-related matters. And first, you'll hear from Kellen Stevens. He's our senior transactional attorney at DLHA Law. He formerly worked in-house in banking and commercial lending. He now supports our business clients for companies of all sizes, and he leads our DLHA trusts and estate practice. So we have a content-rich webinar for you today. Let me just dive right in by handing it off to Kellen. Kellen?
Hi, Angela. Thank you so much for the introduction. Hello, everyone. So I'm the contract attorney, or transactional more broadly. So I'm going to talk about a few things in contract law. This might seem a little boring, so I'll try to keep it top level, and just you wait, because Angela has some great practical advice that we've seen for avoiding lawsuits. But what I'm going to go over, I think all of these, when implemented, can really help you to avoid a lawsuit. So the first thing that I want to talk about is indemnification. And if you're not familiar with what this is, it's just compensating someone for a loss via contract. It's you agree to do this. And it's a risk-sharing tool for businesses. And when you, or risk shifting, and when you shift a risk, you may avoid a lawsuit because someone else is agreeing to compensate for that loss. You'll typically always see this in the titled section, or it'll say indemnify, defend, and hold harmless. And it allows you to kind of control your liability for certain events, and as long as you agree to indemnify for those things. And the most important thing, I think, is you want to understand what you're indemnifying someone for. You can ask them, you can ask your counsel, but you just want to be wary of something that doesn't like spiral out of control. Like if you indemnify them for third-party intellectual property claims, sometimes we've seen that get very, very, very expensive, but there was no limits in the contract. And so it's important to review and visualize these different risks and be comfortable with what you're providing. I think the most important thing is to, and I'll probably repeat this in my other slides, is just the language should reflect your understanding of the risks. And if you don't understand that, then you just generally ask, because if you don't ask and you don't clarify, then you are likely accepting risks that you have not bargained for. And that always leads to lawsuits. So next, I'd like to talk about limiting liability. So generally, a limitation of liability will preclude certain damages, or maybe it puts a cap on an amount owed. You can limit this this cap, and you can kind of control what you might pay in a contract if something goes wrong. The whole point of limiting liability is to avoid a windfall. You want to look at what you could be liable for and say, is this proportional to the value that I'm getting from the contract? So proportionality is the key. You can think about who's likely to get sued or the nature of the, performance or the goods or the products involved, just to get an idea, but you really want to avoid a windfall. And one of the most important ways to do that is to limit indirect damages. So these are things like lost profits, loss of use, or maybe attorney's fees related to those things. If you happen to breach a contract and you don't have an exclusion for indirect damages, then that other party can sue you for the failure of their business to generate profits while they were unable to perform their services. And they can link it to something that you did. If you exclude these things, you're vastly decreasing the universe of claims that someone can file against you, which more likely avoids litigation with respect to those types of claims. Now, another great tool that is more common, I think, in agreements, I'm seeing it more and more, and I think it's always been pretty common, is just the liability cap. This can be a specific dollar amount, a multiplier, even a formula. But the point is that you're putting a specific cap on the amount that one or both parties will pay for a breach. And this can be just incredibly helpful because even if there is that breach, people may or may not sue to get more from the contract or more from the breach because they've already agreed that there's a limit. And so they might be able to kind of negotiate in good faith about what that payment should be if they think that there was a breach. Next, I wanted to just touch on representations and warranties because these lead to claims. And so we often see in contracts, people have a reps and warranties section, and those words are used interchangeably. And they don't always review them thoroughly. Even when we make changes, we'll see the other side doesn't always. And it's just important to understand that reps and warranties are a basis for claims. You're stating certain facts that someone, if those are breached, they can sue you and say, you stated one thing, this wasn't true, therefore I have a claim. If you limit your reps and warranties, you limit the ability for them to have claims, and that reduces the likelihood that you're going to be sued or be involved in a lawsuit where you can't just immediately defend yourself and dismiss it because you didn't represent something that you weren't comfortable with. That's why it's really important to read this. You might see pretty standard reps and warranties about not being insolvent, being a registered business with the Secretary of State. More specific ones, depending on how close the relationship is between the parties and their understanding of what they're going to be performing. But it's just really important to review these pretty carefully, just to ensure that you're never creating a basis for a claim that you don't fully understand and that you wouldn't agree to anyway. Now, all these claims eventually end up, well, not all these claims, these are all ways to reduce the likelihood of disputes. So the next thing I want to talk about was dispute resolution. This is so important, I think, for all parties to consider when entering into a contract. Is just come up with these different mechanisms to resolve things before litigation. If you already have indemnity language for certain claims, if you already have liability caps for others, and then you include these like good faith negotiations between the parties or, a responsible or party representative, then you're able to perhaps deal with possible claims or breaches without resorting to litigation. Now, you can also embed mediation into a contract. This is usually a shared cost and it's non-binding, but it is a low-cost solution relative to litigation that some people, when they're before an objective third party, instead of perhaps maybe two presidents or officers of two companies arguing with each other, they're before that objective third party, they might be more likely to agree to a resolution. And that objective third party will say, hey, look, I know you have a liability cap in your agreement. you indemnify for these certain claims. It seems like you're on the hook here. Instead of litigating, I agree, right? So this is what they can really do is help with that. The last option is to use arbitration. This is kind of like I'm going, decreasing severity here. It's also probably increasing cost overall. These are generally longer sections that should be reviewed by the attorneys and the parties to make sure that they understand not just that arbitration is there, but what does arbitration cover? Because you might exclude certain claims. And what are the costs like? And what are the notice periods? And is it binding or not binding? These are all really important because you want to understand these risks and just like what it covers, because anything that you're unclear about or that it doesn't cover could be a separate claim in litigation. And then you're not avoiding any lawsuit if the arbitration provisions weren't comprehensive enough for what you expected to occur during a dispute. The last thing that I wanted to touch on was insurance. I bring this up in contracts because we can have these sections that require certain types of insurance. And a lot of times, one way to avoid a lawsuit is to have insurance that covers claims so that when those occur, you pump it out to your insurance company and then they pay for the breach or for the failure, for whatever it is. And that way, I mean, sure, your insurance premiums might rise, but you're avoiding going through a lawsuit that can maybe personally name you or include your business and just kind of the whole process, the expensive and time consuming process of litigation. So that's why, insurance is here to settle those claims before you have to litigate them. But with insurance, there's just some things I want to reiterate here. One of them is that, it's really important to review your policy. Policies are meant, well, they've been drafted over time by large insurance companies, and even for lawyers, they're hard to read. But it's important that if you think that something is covered, to confirm that it is covered in your insurance policy. Now, how do you do that? You can ask a lawyer to review it for you. You can also ask your broker or maybe the carrier for specific questions. They might be reluctant to answer some, and they might just say, refer to the policy. But it's always important to ask as many questions as you can so you can get a sense of what that coverage includes. Now, the reason why that's so important is if you saw during COVID, a lot of businesses had what's called business interruption insurance. And they thought that due to the government shutdown and the pandemic, their businesses were interrupted because they literally could not open them, and that they should be covered by the insurance they were paying for the past 2, 5, 10, 15 years. However, most of those insurance policies did not pay out because there was no physical damage to the property of the business. And that was a requirement, was that there's physical damage. And there were court cases saying, well, does a virus being present in it constitute physical damage? And for the most part, court said, no, it doesn't. Physical damage is, there's a flood or there's a fire or a telephone pole falls on your business. And if those things shut it down, yes, and business interruption pays, but otherwise it doesn't. So it's really important to read that policy or talk to someone to make sure that you get what you're expecting. It's that whole bargain for exchange. Accept the risks that you want to, but know what they are and be willing to pay for them. That's kind of the theme that runs through all these types of the contracts. Also, just touching on, general liability, claims have increased, I think, or the party suing, and so it's always good to double check your general liability coverage, see if you should increase it or maybe if you should get like an umbrella coverage. And then finally, I just wanted to touch on cyber liability. We've seen an increase of malicious attacks, malware, people whose computer systems have been breached, and that led to them failing to do something that they were obligated to do in a contract. So then they breached the contract and then they got sued. Now, if you have a comprehensive cyber liability policy, you can possibly get them to pay for that breach of your contract because you can track it back to the malware, right? Or what should be covered in the cyber liability, but you have to read the policy to make sure that it covers what you think it does. And those are also getting a little bit more expensive. So I just it's good to look at that now and see if it's something that would protect your business interests, so that you don't have to get sued over something, over a breach. You can just say, you know what, I have cyber liability coverage. Let's talk to them and they can cover it. So those were the highlights of my contract, important contract clauses. I'm going to hand it over to Angela with some more practical advice from her experience.
Thank you, Kellen.
You're welcome.
Yeah, that's very true. We have seen an uptick in cyber security issues. So I'm going to now pull back a little bit and start looking at general overview, 30,000-foot view issues that we've seen come up for companies, employers, and business people that we see a common thread here. And I'm going to start with something pretty general because we see all types of scenarios in our business. And normally when people come to us, it's when they've either been sued or there's a threat of a claim or they've received a demand letter from another party or the other party's attorney. So it's nice to be able to give a presentation where we're talking about best practices to try to avoid that. And some common scenarios that I've seen in my years of practice and that we've seen as a firm have some common themes. One is that people will come to us and say, I don't need to revise my contract, or I don't need to update our agreements because I've been doing this for, and you can plug in a number, 5 years, 10 years, 15 years, 20 years, 25 years, and I've never been sued. But that doesn't mean you won't be sued. And it doesn't mean that because you know the person on the other side, you may not know their successor, meaning the company that's going to take over or who they're going to sell to, or other investors or other shareholders or their family. Or that person might just change and there might be something that makes them feel that they need to file a suit or claim. So we do see people either with an agreement that's outdated or no agreement. They feel that it's okay to go on a handshake, and we call that the Mr. Nice Guy. I have seen recently a lot of people say, you know why this happened? It's because I was too nice. I, reached out to this person to help them out, or I thought we were okay with the contract we had, or I just didn't feel that we needed to put this in writing or sign something. I thought that it would be okay with the agreement we had. I thought that it would be okay because they agreed orally and we had these emails. Well, that can lead to all kinds of problems. For one thing, what you agree to verbally may not be understood the same way by the other side. What you have in writing, in emails or some brief thing that you've sketched out may not cover, and probably won't cover, all types of scenarios. And also, attorneys look at things differently. We know the language to look for and the language to include. So another thing that we see is sweeping language. If you do have an agreement and you feel that you don't want it to be too lawyerly, too complicated, too verbose, we do see situations where people will try to lump everything in under one section or not make it detailed enough. And the problem with that is that you lose particular protections when you carve out language. And there's language that attorneys understand that needs to be included for your protection, and actual provisions that we need to add back. That leads me to the next part, which is vagueness. Vagueness equals trouble. And a lot of times people will say, I don't think we should get too detailed because it makes the contract longer. But vague terms and vague references can be interpreted all different ways. And that we've seen many, many, many different types of lawsuits based on contracts that both sides thought were clear enough that weren't. So have an attorney look at your agreement, make sure you don't use sweeping language, make sure that you understand what the contract says. And if you feel that your contract is outdated, make sure that the attorney that you use for your business work looks at it and revises it. So that takes me to the next slide, which would be draft defensively. And that, I don't mean to sound paranoid, but when we get lawsuits in our firm, we see the worst of the worst, and we see things that may have been drafted to help both sides, but doesn't protect our client. or helps the other side and doesn't protect our client. And we do need to draft defensively. You need to draft the agreement knowing what are the worst case scenarios that could happen, and are you protected, or are you protected to the best extent that you can be? We have clients come to us a lot, even large clients that are working with very big companies, and they'll say, we don't think that we have any latitude to change this agreement. And 9 times out of 10, that's not true. 9 times out of 10, making something more clear for your side, or even just the contract in general, the other side will be open to that because they don't want it interpreted against them, even if it's a large company. So there's often a lot more latitude than people realize. I know this looks ridiculous, but we see many times we'll get a contract even from large companies because they may have MSA, which is a master service agreement, and then they may have additional contracts or amendments that aren't signed. And the scopes of work or the amendments or the changes are what modify the master service agreement, and those need to be executed. They need to be signed. So any change to a contract or even the main contract has to be executed, and it has to be executed in a particular way. You need to be sure that the person signing the contract has the authority through the corporation, meaning the minutes authorize that person to sign on behalf of the entity to sign. If they don't, there's exposure. So if the secretary or the vice president or the president has the authority to sign through the founding documents, the corporate authorizations, then that's fine. But if they don't, the contract could potentially be attacked in a claim. So make sure that the person signing has the authority to sign. And I'm going to talk a little bit about compliance here, which isn't on the slide, but it goes with the person signing the having the authority. Make sure that the parties entering the agreement represent the entity. So you don't want your individual name on a contract as the party. You want the entity as the party, and matching that where there's the signature line, you want the name of the party signing, but you want them signing under their authority in that organization. So for example, I might sign, but it needs to say CEO and then the name of the entity with the Inc., corporation, or LLC on the signature line underneath. That's really important to show that the person signing isn't personally guaranteeing the contract. That keeps personal liability outside of things. So let's go to the next slide. The other thing we tend to see are patchwork agreements. This is where a client may come to us or another attorney, get a set of documents, have their agreement drafted, and then they feel that they're protected going forward for future agreements. So they take that one agreement and they start adding language or cut and pasting language from the internet or cut and pasting language from other agreements, or the other side starts patching it together. Those are really dangerous. For one thing, attorneys know how to look for contradictory terms in an agreement. For another, most often than not, it makes the agreement very confusing. There may be references to defined terms that don't work. There may be references to clauses that don't match. So you want to stay away from patchwork agreements. Most agreements need to be reviewed if they're modified at all. And the other one is internet agreements. Internet agreements keep us very busy because there's a lot of lawsuits that are filed using agreements that are pulled off of the internet. For one thing, they're too general. They usually have a lot of provisions that don't apply. They're not tailored for a specific business or industry. They don't have protections in place for your business. And we add a lot of provisions that are tailor-made. Jurisdictional provisions, for example, discussing what type of jurisdiction will govern, what court will govern, whether it should or should not be arbitration or mediation. And those are discussions we need to have with a particular business owner to identify strengths and weaknesses and positives and negatives of all different types of dispute resolution before we make that decision. So you're not going to have a conversation with the internet. They're not going to guide you through that. So we stay away from those. Next slide. This is my favorite. So in addition to make sure everything's in writing, because if it's not in writing, it doesn't exist. I want to say, be careful what you put in writing. We live in such a very an age of technology where everything happens so rapidly and people expect immediate responses and they expect information to be transferred quickly. So when you as a business owner or someone working with a business are sending information, you have to be so careful about what you put in writing. When we are handling things and we're handling cases for our clients are often shocked to find out that yes, your text messages are discoverable. And yes, you do have to produce all the documents and all the emails that you prepared. And there's oftentimes a lot of information that people don't want transferred to the other side that we actually have to produce. So I like to say, before you send something, an email or even a text, imagine that email or text blown up and highlighted in front of a jury. And if you're comfortable with sending it when you imagine it highlighted and blown up on screen in front of a jury, then you go ahead and press send. But be very careful. Like, we had a case years ago where an employer had hired an independent contractor and one word changed the entire climate of the settlement and the amount. And that word was salary. And they didn't even think about writing the word salary. It didn't seem like a big deal to them. They just put the word down in an email. The email came up. That meant that there was an implied agreement that the party was an employee, and that made the settlement amount go way up. So that simple thing, a year before in an email changed the whole climate of the case. So before you press send, and oftentimes our clients will come to us when they're seeing that there is a potential dispute arising and have us help them with emails that they're drafting, which is incredibly useful and keeps them out of a lot of trouble. So before you hit send, think twice, contact your attorney if you think it could cause problems, and email us if you have other questions about all that. And with that, I'm going to turn it over to Lindsay Meyer, who's going to talk to you about employment matters. Lindsay?
Thank you, Angela. Good afternoon, everyone. Thank you so much for joining us today. It is my pleasure to present. As Angela mentioned earlier, I'm going to be covering highlights pertaining to strategies for employers to prevent employment-related litigation. Now, litigation is so expensive, so anything we can do to help our clients avoid getting involved in litigation in the first place is what we try to achieve for them, because really that, in the long run, it saves so much money for our clients, so much headache, so much disruption of the business. So one of the first major areas that employers can act on to prevent employment-related litigation is to keep their handbooks and their company policies within the handbook, or if they have separate policies, outside of the handbook, perhaps updated based on current law. So it is critical that those are kept updated in compliance with current law for California, and if you're outside of California, for the state that is relevant to that particular set of employees. Now, you would be surprised, many businesses actually operate without a company handbook in place. It's easy to understand how that can happen. Business owners are extremely busy with setting up and running the business and all of the day-to-day responsibilities, and they're not able to carve out time to sit down with their legal counsel to figure out what company policies and procedures they actually want to have in place. But I cannot stress enough how risky it is to operate a business without a written handbook outlining one's policies and procedures, or making sure that your operating handbook is in compliance with current law. Because on the other hand, we often have new clients come to us and they have a handbook, but it was drafted 10 years earlier and it's never been updated. So clearly there's going to be a lot in there that is not in compliance with California law. Now, California, as we all know, is a very challenging state to be an employer in. And besides the laws being very employee deferential, significant changes in employment laws are generally made on an annual basis. By around early October each year, we know much of what the new laws will be going into effect for that coming new year. So our clients come to us in that last quarter and they have us update their handbook. So they go into the new year in compliance. If you are operating right now without a handbook in place or a very outdated handbook, please reach out to us or your legal counsel so you can get one in place ASAP. But as far as ensuring you're updated on a regular basis, the best time to reach out to your legal counsel is around the last quarter of the year, because that's when the new laws are available, so the handbook can be appropriately updated going into that new year. Now, just to give you an example of how this can become problematic operating with an outdated handbook, recently there was a very significant change in the law that impacted employers and employees, and pertaining in particular to what should be contained in a handbook. Now, it was an expansion of the California Family Rights Act that we refer to as CFRA. So until the end of 2020, CFRA only applied to private employers of 50 employees or more. But as of the 1st of January of 2021, so just a little over a year ago, CFRA now applies to private employers of 5 employees or more. So that really applies almost to any business operating with employees, because most organizations have probably at least 5 employees or more. So that was a huge change for many of our clients, and they had to get their handbooks, updated to make sure that they were in compliance with that change in the law. And for those employers who were out there that had existing handbooks that were not updated to reflect this change, they likely were unfortunately applying outdated policies relating to their employees' leave rights. So certainly not providing an employee their full entitlement or withholding any rights, even if inadvertent, would leave an employer exposed and ripe to have a claim brought against them. And again, as you know, any litigation matter, especially claims related to employment violations, can be very costly, because not only are there, the unpaid wages, for example, or overtime, there are potential penalties and attorney's fees that employers could be responsible for as well. So again, this can all be avoided by reaching out to your legal counsel at least once per year to ensure your handbook is up to date. And then this will help the company as a whole stay in compliance and on top of any changes in the law, but it will also help keep the company's employees informed of all the pertinent changes and their rights as well. But most importantly, making sure your handbook and company policies are up to date will minimize your exposure as an employer by ensuring the employer is applying the policies that are in line with the most updated employment laws that are available. Regarding company policies being updated, that certainly is specific to an individual company. However, it is important to keep all policies updated internally to avoid any ambiguity in the enforcement of such policies. Now, we have had some issues come up where an employer will come to us where they have an issue relating to a particular employee. For example, they might have a policy where they want to enforce a specific dress code and the employee is not following it and they want to discipline that employee. But we look at their company handbook and the policy that they're trying to enforce either isn't in there or it's in conflict with the policy they're trying to enforce. So obviously that will be very problematic for the employer if the employer is seeking, for example, to discipline an employee for a policy that is not actually contained in the handbook or is in conflict with one that's in the handbook. So again, it's just important to keep all those internal company policies up to date every year, as well as the making sure all policies contained within the handbook are in compliance with California law. Now, as COVID, we're all so tired of hearing about COVID, but there was a recent update just this month for the Cal OSHA COVID-19 Prevention Emergency Temporary Standard, the ETS. I will not go into detail on this because there are a lot of significant changes that were recently made. So it is important for you to take a look at that because the ETS is going to be in effect, and this revised version is in effect as of May 6th of this year. So just this month through the end of the year. So you just want to make sure your COVID policies that you have in place are updated and in line with this recent change to the COVID ETS. And if you have any questions, please feel free to reach out to us on that. Now, switching gears a little bit, another way to avoid employment-related litigation is for employers to ensure their workers are properly classified. If employers ensure proper classification, they can avoid numerous claims, which otherwise could be brought for violations of the California Labor Code. Now, ensuring workers are properly classified, you want to look at first two areas would be, if you're looking at an employee, is my employee exempt or are they non-exempt? Now, California laws require most employers to follow certain rules pertaining to their employees, such as paying overtime, tracking employee hours, and providing meal and rest periods. Employees are entitled to these rights and are non-exempt. Employees that are entitled to these rights would be classified as non-exempt employees. And the majority of most of the, I would say, most companies' employees are going to be comprised of non-exempt employees. However, there are certain positions that are permitted to be exempt from these requirements of the California wage and hour laws, and these type of employees would be considered exempt employees. Now, in general, to determine whether an employee is exempt under California law, first and foremost, that employee, their salary will have to meet the minimum salary test. That means the employee's salary must be paid at a rate that is at least twice the minimum hourly wage based on a 40-hour work week. Additionally, the employee's primary duties must consist of administrative and executive or professional tasks, and independent judgment is also necessary, meaning the employee's job duties must also involve the use of discretion and independent judgment. So generally, if all three of these requirements are met, the employer will usually be classified as exempt from overtime. The employee, will usually be classified as exempt from overtime, overtime, minimum wage, and rest break requirements. Now, of course, this evaluation must be made on a case-by-case basis and is very fact-sensitive. Accordingly, it's not surprising that many employers often misclassify employees. For example, it is a hugely common misconception that if an employee is given a title of manager, the title alone will permit that employer to classify the employee as exempt. And that is absolutely not correct. The employee's job title is irrelevant to the determination as to whether or not that employee is properly classified. Rather, the manner in which the employee is paid and their specific job duties actually performed and their ability to use discretion and independent judgment are the keys to determining proper classification for exempt status. Now, independent contractors, employers often would like to hire, and this has become so much more difficult to classify a worker as an independent contractor over the years. As of the 1st of January 2020, their AB 5 went into effect. And basically that requires an application of a test called the ABC test to determine if a worker in California should be an employee or an independent contractor. And that's for purposes of the Labor Code, the Unemployment Insurance Code, and the Industrial Welfare Commission wage orders. So what is the ABC test? Well, to give you a very snapshot idea of what it is, under the ABC test, a worker is considered an employee and not an independent contractor unless the hiring entity satisfies three conditions. And those conditions would be: one, the worker is free from the control and direction of the hiring entity in connection with the performance of their work, both under the contract for the performance of the work and in actuality, in fact. Two, the worker is performing work that is outside the usual course and scope of the hiring entity's business. And three, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So a lot of our clients, when they ask us, how do we apply this ABC test? I've always used this particular position I've classified it as a 1099, as an independent contractor. I always give this example. If you're a marketing firm and marketing is the crux, the core of the work that you do, and you hire a plumber who has their own independent plumbing business. Plumbing is not anything that is at the core of the work or work that your marketing firm does whatsoever. And the plumber is allowed to come in, do his work as he sees fit without, much direction at all from you, the marketing firm, well, that individual most certainly could be a 1099, is an independent contractor. But if you want to bring in somebody to assist with the marketing work, and that individual would just be working on a specific project, but so even if you're giving them, kind of control and discretion how to work on this particular project, and maybe they even do work for hire on the side, but if they're doing that same type of work as the core and crux of your business marketing, then that person unfortunately cannot be deemed an independent contractor. They're going to have to be an employee. So again, it is much more difficult now to classify a worker as an independent contractor. So again, there are exceptions to this rule though. So it's very specific, again, depending on the type of position and worker you're trying to classify. So always reach out to your legal counsel just to make sure that you are classifying every worker correctly. Next slide, please. Another strategy, which is probably very common sense, but I thought it was really important to mention for employers to prevent employment-related litigation, would be ensure that your organization is maintaining accurate time cards that reflect not only the employees' in and out times for the day, but also when they're taking their meal periods. Now, employers are not obligated to employees, typically don't clock in and out for their rest breaks because those are 10-minute increments, but employers absolutely do need to keep track of when the meal period is being taken, because an employee must be permitted to have their uninterrupted duty-free meal period before the end of their 5th consecutive hour of work. So that is where a lot of employers, unfortunately, they get hit, because either they're not having their employees actually write down a time when they're starting their lunch and when they're ending their lunch. And then they will end up having meal period violations for every day that employee worked for a whole year, for example, because if an employee comes in and they never document when they're taking their meal period, or if they're taking their meal period, but they're taking it after the 6th consecutive hour of working, again, the employer is going to be in violation of the labor code. So it's really critical to make sure your organization understands what those entitlements are when those meal and rest periods need to be taken, and also that the records are accurately reflecting what the employees' in and out times are. So there's a lot of different items that should be reviewed when looking at a time card. So if you have any questions, reach out to your counsel. But it's an actual relatively easy thing to do, but it's something that gets overlooked on the day-to-day. And I have so many clients that come to us and they feel so terrible because they were giving their employees breaks and they just didn't understand that it wasn't up to the employee when they took the break. There was an actual specific time period within which the employee had to take that meal period. And then they're going to get hit with those penalties. It's pretty black and white under the labor code, unfortunately. So again, if you have any questions, please feel free even to ask at the end of this webinar. I'm happy to answer. Next slide. And lastly, I just wanted to go over as far as preventing employment-related litigation. It is really important as a business owner to understand when is it a good time to consult legal counsel. There are a lot of things that the business owner can do on their own, but there are certainly times when it really will save the employer a lot of money in the long run if they reach out to their legal counsel on the front end instead of later down the line when dealing with issues in the workplace. So the 3 main areas I would suggest that employers consult with their legal counsel at the onset, first and foremost, would be on the onset of any employee discipline issue. Especially including if you want to terminate employee, you should reach out to your legal counsel, but most certainly you should be reaching out if there's an employee who's not following company policies, is being insubordinate. Reach out to your legal counsel so they can walk you through and help you draft the written disciplinary notices, and making sure that what you are documenting and putting in writing is not going to come back and bite you in the end. Because at some point, a problematic employee will probably have to be let go. But how you go about that and how you've kind of prepared yourself to do that from the beginning is really critical. Now, another time that would be really important to consult with your counsel would be when dealing with an employee request for an accommodation based on a medical condition, disability, or perhaps their religion. The employer is obligated under California law when it comes to a disability or medical condition to engage an employee in what's called the interactive process. So you want to be documenting what you're doing in writing for that employee, so you don't open yourself up for any type of claim that you haven't, engaged that employee in a good faith effort in the interactive process, or that you failed to accommodate this employee. So again, that is another real critical time, because there's a lot of intricacies that go into ensuring the employer is complying with that part of the law. And lastly, another big area where employers should consult is when dealing with an employee who is complaining of harassment, discrimination, or retaliation in the workplace. And again, each one of these scenarios is going to be extremely fact specific. So there's no kind of, step-by-step how to handle these, but the employer should have a policy already in place in their handbook. So an employee who wants to make a complaint regarding feeling harassed or discriminated in the workplace, they know what steps they can take and how they can make those contacts with the employer to get some assistance on that matter. But again, the employer then will have an obligation to do an investigation, possibly to interview individuals. So it's really critical that the employer reaches out to legal counsel, even if it seems somewhat like a mundane complaint, or every single one of those complaints should be taken very seriously, because they can escalate very quickly. Recently, last year, there was a $137 million single plaintiff verdict awarded, and it was in a it was awarded by a federal jury in San Francisco. And it was pertaining to a case regarding an individual employee. He was a former Black California-based elevator operator. He worked for Tesla Inc., and he had complaints of racial discrimination, hostile work environment, failure to prevent harassment, those types of claims against his employer. And unfortunately, the way that the employer handled the situation, the jury didn't find, adequate, and they ended up getting, they awarded the plaintiff, Mr. Diaz, $6.9 million for emotional distress and $130 million in punitive damages. So again, I'm just telling you this because with this massive verdict, and of course, here in California, it's something that's possible. It should be a wake-up call regarding how seriously risky jury trials relating to employment discrimination and harassment can be for employers. And as a practical matter, this verdict should be a reminder for employers just to revisit their internal policies, consult with their legal counsel to see if there's any areas where they can strengthen such policies. Maybe they can work on more rigorous training for their upper management to how to handle these types of situations, and definitely ensure there are measures in place for the employer to swiftly and thoroughly vet and escalate any complaints and information relating to discrimination or harassment in the workplace. And with that, that concludes my portion of this webinar, and I will turn over to Miss Angela De La Housaye Ashley. Thank you very much.
Great. Thank you, Lindsay. Thank you, Kellen. So this is the point in the webinar where we turn to you all and see if there are any questions. We see that 3 have come through, so let me go ahead and send those to the different attorneys that can answer them. And in the meantime, if you think of anything or have any other questions, please do add them to the Q&A box. If we don't get to them today, we will email you directly to help you out with the answer. We'll likely stop exactly at 1 o'clock. So again, if we don't get to your question, we'll go ahead and email you directly. So the first question is, which is more expensive, arbitration or mediation? And Kellen, can I give you that one since you covered arbitration and mediation in your presentation? You're on mute.
Thank you. Yeah, of course. So, kind of like in the same way that I set it up in our slide, looking down how you're escalating, good faith mediation and arbitration. And then probably below that is litigation. So that's generally, you expect mediation to be less expensive because you're not going through, it could be 1 day, maybe 2 days. You're not going through the same process. Arbitration can sometimes involve including a lot more evidence and there's more rules that apply to it. Whenever there's more rules, it takes up more time and there's more costs. So I think generally, yes, mediation is the cheaper alternative. That's why it's usually the first resort for most disputes between parties. And then if that when that fails, you can then move to arbitration, and whether that's binding or non-binding.
Good, thank you. The next question we have is, why do I need to incorporate if I have insurance? And I can answer that. We get that question quite frequently. A lot of times when business owners come to us and they have a corporation, or when they're looking to set up a division or another entity. So there's a few reasons. One is that insurance, depending on the type of insurance you have, whether it's like Kellen was talking about, business interruption insurance, liability, employer insurance regarding employees, or there's a whole host of cyber insurance. It will apply to specific situations and scenarios and factual scenarios, but there are reservations that are taken out and exceptions that are taken out of coverage. And so in order to understand what is exactly covered or isn't, you have to go through your policy very carefully and figure out if that particular issue is covered in fact by insurance, or a lot of times if there's a lawsuit, the other attorney will be savvy enough to include some claims that are covered by insurance and some claims that are not covered by insurance. So for example, some negligence claims might be covered by insurance, but some intentional torts may not. So, insurance doesn't cover you for everything. Insurance also has obviously caps on what it will cover. The policy provisions will have a ceiling. And then also there are other situations where people just don't want their insurance to be applied and they don't want to be involved in a lawsuit. For one thing, if you have insurance and the other side is going to sue you and you're not incorporated, they're going to include you individually. If you have a DBA, which is not the same as a corporation or even a partnership, they're not going to, there is no entity to sue. They have to sue you directly. So you'll be involved in a lawsuit. Most suits are public. And accessible on the court's docket by other parties. You have to disclose it on your on any insurance you have that you're applying for, or loans or things like that. There might be questions about whether you personally have ever been sued. So there's a lot of different reasons why people might want to incorporate to keep their personal liability, exposure, or their individual name off of a claim. And the other thing is that insurance is likely not going to file a counterclaim for you. So if you're involved in a lawsuit, even if it's your entity or your company that's involved in a lawsuit and you turn to your insurer, the insurer is going to do what they decide is best. They're going to settle if they decide that's best, and they're not going to be filing a counterclaim for you or a cross complaint. So those are a few reasons why you want to keep your individual assets off of claim. The last question is, when am I entitled to attorney's fees in a contract? And I'll turn that over to Kellen.
All right. 2 of the 3 so far. Okay, fantastic. I guess it depends generally. There are certainly in a contract, you can have clauses that set aside specific attorney's fees provisions. And those can say that, for example, if there's a breach or if there's a suit, and related to that, if there's like a final judgment, the prevailing party gets attorney's fees. We'll see that a lot. So that's kind of prevailing party language, which can be included. Depending on what the claim is, certain statutes, right, like allow for recovery of attorney's fees, like a fraud, for example. So that's possible as well, but that's not really a breach well, it could be, I mean, according to a contract. So, it does depend on that. You generally will see a section that will either be called attorney's fees or prevailing party. And then also in the indemnification section, they might have there, like, paying for the reasonable attorney's fees to cover a claim. And so that's where you would be on the hook to defend someone or pay if they have to then pay for attorney's fees because of a claim that you agreed to cover in the indemnification section. So that's where we typically see them.
Okay, that's perfect. And are there any employment questions that you see typically arising, Lindsay, from clients or coming up?
There's actually there's so many questions that I
Yeah,
see coming up regarding
yeah,
employment related. So
yeah,
it's hard to pinpoint just one really. I mean, I think most clients are very interested on when, they should get their handbooks updated. Do I have to get them updated like every month? Is it a once a year type of thing? If you have a handbook in place already, the good time to have your counsel update it would be the last quarter of the year. And if you have any questions otherwise, then that's, I
okay,
think, I think it's, you kind of have to take it on a month by month basis. If there's some policy that you want updated, you might want to have us or your counsel help you with that. But generally, you only need to have it updated probably once a year in that last quarter of the end of the year. So going into the new year.
yeah, that's a
Yeah.
great question. And as Lindsay said, a lot of times what we'll see is one issue will come up with the employer, and so we'll be able to address that just with the policy paper going out and people sign off on that instead of updating the whole handbook.
Right.
Well, that concludes our presentation. Thank you so much for giving us your time. Please do feel free to reach out to us at info@dlhalaw.com. Have a wonderful rest of the day. Take care. Bye-bye.
Thank you, everyone.